Hi, everyone. Welcome. My name is Jason Q. I'm a managing attorney for the Nonprofit and Small Business Legal Assistance Programs at the DC Bar Pro Bono Center. First and foremost, I'd like to thank the folks from the DC Department of Employment Services and Office of Paid Family Leave for joining us today to talk to nonprofit and small business employers about the incoming Paid Family Leave program. A few logistical notes before we start. If you look to your GoToWebinar panel, you'll see a handouts tab that will allow you to download a copy of the handouts for today's presentation. You will also see a questions field. During the presentation, you can type in questions and I will relay them to the presenters based on the amount of time that we have to do so. You also have the option of submitting questions before the event. Again, if we have the time and if it feels appropriate, we will hit on some of those questions as well during the presentation. Finally, before we start, I'd like to plug another employment-related webinar that is happening tomorrow at noon. The topic is Reopening the Office, Considerations for Bringing Back Workers Safely, a very timely and important topic. You can find a link to register to that webinar along with our library of COVID-19 related resources, employment law related resources, and other nonprofit legal resources at probono.center/NPSB. That's PROBONO.center/NPSB. So with that, I'd like to turn it over to our speakers for today, Michael Henderson and Elliot Skur. Please take it away, Michael.
Good afternoon, and thank you. I am Michael Henderson. I'm a program analyst with the Office of Paid Family Leave, and very much grateful for the opportunity today to speak with you regarding the implementation of the district's new paid leave program. We're going to give you an overview of some of the activities related to the program, but primarily our goal today is to hear your questions and provide answers as best we can. And with that, I'll give it over to Elliot.
Thank you, Michael and Jason. And hello, everyone. My name is Elliot Skur. I'm a policy analyst with the Office of Paid Family Leave. And we are very happy to be here, continuing our outreach efforts during times of social distancing. So we'd like to just start off with just some basics about the program. Many of you are probably aware, but we just want to make sure that everyone's on the same page. This program exists to provide paid benefits to individuals who need to take leave from work in order to take care of qualifying events. And those qualifying events fall into three categories: parental leave, family leave, and medical leave. Parental leave means the birth of a child or the welcoming of a child into your household through adoption, foster care, or some other legal means of taking custody of a child. Family leave means to take time off from work to provide care or companionship to a family member with a serious health condition. And finally, medical leave means to take time off from work to take care of your own serious health condition. We can get into more details later about the definition of a serious health condition, because this has very specific meaning within our program. It's not necessarily what you would use sick days to take care of. It's closer to temporary disability insurance. So on the next slide, we'll see just some details about the family members that are covered under that second type of leave called family leave. Our program does require that it is a family member who falls into one of the categories you see on your screen that a worker takes time off to provide care to: children, parents, grandparents, siblings, and spouses. Although each of these categories is very broadly defined to include step, half, foster, adoptive, and so on. There's many family types that our program covers, but it does have to be a family member in one of these categories that a worker takes time off to provide care to.
We also wanted to take a few moments to talk about some employer responsibilities with our program. You see here there are four key categories of these responsibilities. The first being registration, Most employers are already compliant with this, given that we use the employer self-service portal, which is used for the unemployment insurance program, to process the collection of wages and taxes. So most employers already are registered here and have either their own business handling the wage reporting and tax payment, or they have a third-party processor acting on their behalf. The second responsibility ties directly to that, which is the payment of taxes. As stated, we began collecting taxes last summer to fund this benefit, and these taxes are collected on a quarterly basis in the same method that happens for the unemployment insurance program. And then we have our notification requirements, and this is going to be one of the most important aspects of the program for the purposes of employers, because there's some very distinct times that notices have to be provided to their employees. The first thing you see here is that a worksite poster or notice is required, much in the same fashion as some of the other labor law posters that are used by the Office of Wage Hour Compliance or the Office of Unemployment Compensation. So you must have this notice posted in a conspicuous place at your worksite. You also must provide this notice at 3 distinct times, or at least 3 distinct times for your employees. The first being at the point of hire. So any new employee must be given a copy of this notice. Very often it could be included in like a welcome package, or however you typically bundle your documents when you bring on or onboard new staff. You also must provide this notice at least once annually to all of your staff to ensure that they're made aware of the program and any changes that may have occurred. And then finally, whenever an employee makes their employer or supervisor directly aware of the need or the potential for need to use paid leave, you want to make sure you give them a copy of that notice. Our law does require that employees provide at least 10 days notice to their employers before they go out and leave. So that would be the appropriate time to provide a copy of this notice once they notify you of the intent or the need to apply for benefits. And then finally, we have the record keeping requirement. Again, most employers are already compliant with this because the records that we're asking about or we're talking about here are going to be wage related, employment related, payroll records, much like the records that are already being kept for the purposes of wage hour compliance, minimum wage, and the Office of Unemployment Compensation. And then an important reminder to make sure you keep these records on hand for at least a period of 3 years. And this segues very well into our one of our big topics from the perspective of employers. Many people have been asking us about how benefits are coordinated and what may or may not be the restrictions and what may or may not be allowable. The first thing we want to remind everyone is that employers have the ability to dictate or to establish policies or modify policies in order to control how their benefits work with the district's program. The most important thing to remember, though, is that employers cannot restrict, delay, or prevent an employee from applying for or receiving benefits from the district. So employers have a number of different ways that they can choose to have their programs wrap around, augment, supplement, run concurrently with the district's program. However, we won't be offsetting for any external benefits. So if you have your own short-term disability plan or you have a short-term disability policy through a third-party provider, the district won't offset the benefits that we pay to employees. And we'll go a bit more into detail about how some other coordination happens among leave laws. But again, our office will notify both the employer and the employee, with regards to a claim being filed, as well as with regards to whether or not a claim is approved. Now, the notice that is sent to employers by default will not include information about the weekly benefit amount, the benefits that the employer is receiving. However, we are going to strongly encourage employees to provide that authorization, to authorize us to give you that weekly benefit amount, because of course, it will likely be essential to employers knowing how to appropriately coordinate their benefits. Employers also have the ability to make their own benefit programs contingent upon that information. So you could say, in order to participate in your program, the employee must notify you of the amount received from the district. And that can be either through the authorization so that we add it to the notice, or they can just provide you a copy of their notice directly.
So this brings us to a discussion of what the benefits are that would be coordinated by employers. And we'd like to start with just an overview of the benefits from the perspective of our calculations. So our benefits are based on the wages paid by covered employers in DC to workers and are reported to the Department of Employment Services for the purposes of unemployment compensation. Once we get those wages, we use the highest 4 of the 5 completed calendar quarters before the qualifying event as the base period for our benefit amount. Our benefit amount is averaged over 52 weeks. So we take all of that income and we divide it by 52 weeks to get an average weekly wage. And then we replace a portion of that average weekly wage up to 90% wage replacement, as you can see on your screen. That 90% wage replacement is only for the lowest wage earners, the ones earning up to 1.5 times DC's minimum wage. The minimum wage is increasing on July 1st, 2020 to $15 an hour. So 1.5 times of that is $22.50 an hour. So for any worker earning $22.50 or less, they would get 90% wage replacement from our program. The benefit amount increases as wages increase, but the percent of those wages that is replaced by our program declines. So the dollar amount increases, but the replacement rate declines for higher earners. And there is a maximum benefit amount of $1,000. So we'll just run through some examples just to give you an idea of how this formula interacts with real world examples. So if we take someone earning $20 an hour, which is in that range for 90% wage replacement, someone earning $20 an hour at a restaurant, including tips, receives about $800 a week in wages. And so we would replace 90% of that for a benefit amount of $720 per week. Someone earning a higher income, $60,000 a year, equals about $1,150 per week. This person would receive about 80% wage replacement from our program, or $935. And then someone earning an even higher salary of $100,000, which is equal to $1,900 a week, is receiving the maximum weekly benefit amount from our program for the first year of the program. It's going to go up in future years, but for the first year, it's $1,000. And so regardless of how much this person's income increases above $100,000 a year, they would still only receive the $1,000 maximum weekly benefit amount, which for this person represents about 50% of their income. So some more details about the benefits and our processes for receiving them. We only receive claims after a qualifying event has occurred. So this means individuals have to wait until a baby is born or an adoption is complete in order to file a claim, even when that event is foreseeable. And that's because we need to know the exact date on which the event occurred. So it is possible for people to come in and create an account with our online portal, which will be available soon, and to even start compiling the documentation that's required in order to file a claim, but they just will not be able to click submit until after the day of the event. There is a 7-day waiting period, and this is really just a blackout period, 7 days after a qualifying event, when we will not replace income. We will not provide benefits for the first 7 days after a qualifying event, but then someone could receive the maximum number of weeks if they're out after that 7-day waiting period. Our office reviews claims and provides a claim determination within 10 days of receiving a claim, 10 business days, so that's about 2 weeks, and that is a maximum time frame. It could be less, but we do expect to issue claim determinations within 10 business days. And finally, after we approve someone for benefits, they could expect to receive payments every 2 weeks or on a biweekly pay cycle, similar to the way many businesses compensate their employees. This biweekly pay cycle is different from the specific days that the person is receiving benefits payable for. It's the payments themselves are decoupled from the actual days that someone is taking off from leave. The actual payments will come in the form of ACH direct deposit or a debit card. And finally, just to note at the bottom of your screen, you can see that we will be paying benefits both on continuous and intermittent leave schedules. So this means someone could take every Wednesday off if they need to receive treatments for a serious health condition, or every Wednesday and Friday to bond with a child, or so on. We will pay benefits on that schedule, but that does not say anything about whether that employee has job protection for that period, which leads us to the next topic, which Michael will cover.
So we also want to talk about how the different leave laws in the district kind of relate to one another. So you see here on your screen, we have the Accrued Sick and Safe Leave Act, or your paid sick days, FMLA and DCFMLA, that's the Family Medical Leave Act, which is your unpaid job protected leave for serious health conditions, and then the district's new paid leave program. So looking at the Accrued Sick and Safe Leave Act, first, your paid sick days, this is going to typically be for less serious health conditions. This is funded by the employer directly, and while the law does guarantee a set number of days that are protected, so between 3 and 7 days, based on the size of your employer, as you see towards the middle of the screen, many employers offer more leave, whether it be directly sick leave or just a general paid time off bank of leave. This leave type does require an accrual of benefits, so you have to work a certain number of hours to generate leave or to gain access to that leave as well. So you work a certain number of days or a certain number of hours to make use of this benefit. And then we look at the middle section, which is FMLA and DCFMLA. And again, this is job protected, unpaid leave. This is also coordinated directly with the employer. So the employee comes to their boss or to the supervisor with a request to go out and leave, and then the leave allotment is available depending on the type of leave. So whether it's up to 12 weeks or up to 16 weeks. This leave type is also based on the size of the employer. So 20 or more employees or 50 or more employees are the thresholds in order to gain access to this job protection and this leave type. There also is an accrual of leave required, so you do have to work a period of time, whether it be a certain number of hours or in certain cases a year or more with no breaks in order to gain eligibility. Now, the district's new paid leave program is a bit different. So this is a paid benefit that's also for serious health conditions in a similar fashion to FMLA. However, this is funded directly by the taxes that have been collected by our program, and the determinations are made by our office. So your employees will notify you of their intent to file, but they file their claim directly with our office. We then review the information, whatever the applicable documentation is, and then we issue a determination that approves or denies that leave. And as Elliot covered before, we have leave available in 3 different categories, up to 8, 6, and 2 weeks, with no more than 8 total weeks in a given period. This, however, is not based on the size of the employer. So you could have 1 employee or you could have 100. As long as you have wages that are reported to the District of Columbia for the purposes of unemployment compensation, those individuals are covered. Our program is based on the place of work and not residence. So again, that means that the majority of the eligible claimants in our program are primarily going to be from outside of the district, so from Maryland and Virginia. But we always look to first where the wages are reported and where the taxes are paid to determine eligibility. And again, there's no requirement for a certain number of hours to be worked to gain access to our benefit. It all is based on the wages that are reported. So once an individual has wages reported, they gain access to the coverage. But it is important to remember that this is a somewhat self-regulating program. As Elliot covered before, we have a base period. So we look back at completed quarters to then average out your wages. So if you only have 1 or 2 quarters of benefit or of wages reported, your actual wage replacement or benefit amount could be significantly less than if you had the full five quarters to review. And again, an important reminder: the base period is defined off of the date of your qualifying event, not when you submit your application for leave. Now we wanted to move on to the question and answer portion of today's presentation, and we'd like to lead this off with some of the more common questions that our office has received. So can employers coordinate their leave programs with PFL? Again, this is an important topic, and the answer is yes. Employers have the ability to amend or even create policies as they see fit. But again, just please remember that you cannot restrict, prevent, or delay an employee from receiving benefits. Can workers receive PFL for short periods of leave? The answer is yes. As Elliot covered earlier, we do have intermittent or part-time leave. So you have the ability to take leave in increments of at least 1 day. So you could work on some parts of the week and then for the rest of the week, be at home taking care of your qualifying event. But an important reminder, you cannot receive benefits for any day that you are actually performing work. And how do I submit a claim for PFL benefits? We're in the process of finalizing our paid leave portal or website for employees to log on and register accounts. And then after they have have a qualifying event occur, they will have the ability to submit a claim for benefits. We'll have more information about the new paid leave website very soon. So please keep an eye on the dcpaidfamilyleave.dc.gov site. And also, if you're receiving our newsletter, make sure to look out for tips and information there as well. And with that, we can move into the live portion of the Q&A.
Wonderful, thank you so much. So I'm going to try to organize the questions in a sensible way, but we might jump around a little bit. We had a lot of questions about where to find the employee notice that employers are responsible for making available and for posting. So I posted a link in the chat with that available, but I don't know if there's a URL, Michael or Elliot, that you sent people to find those notices.
That link is fine, and also the employee poster is also available at dcpaidfamilyleave.dc.gov. We have 2 primary sites. So we have the dos.dc.gov, which is the main agency site, which does have a section for paid leave or paid family leave. And then we have our standalone site, which is just for our program, which is again dcpaidfamilyleave.dc.gov.
And I will say that standalone site is great. It has a lot of amazing information on it, organized in a lot of different ways. So I would encourage folks to check out that site. Someone's asking, when will you share the actual paid formula? I think I recall seeing a benefit calculator on the website already.
There is a benefit calculator, and I don't, right next to it, it doesn't lay out what the formula is, and I can share that now. But elsewhere on the website that is listed. But just to explain it now, we replace 90% of wages up to 1.5 times DC's minimum wage, and then 50% of wages above that with a maximum weekly benefit amount of $1,000 per week. So there's 2 sort of bend points where up to 1.5 times DC's minimum wage, we replace 90%, 50% above that, and then 0% above the wage that would result in $1,000 weekly benefit amount.
Great, thanks. If an employee is an hourly employee, does any of this change, or how does all of it change? Some employees may only work a few hours per week or per month.
So this program is available to full-time, part-time, temporary, or seasonal employees. As long as the wages are reported to the district, then they're used to develop the base period. So a number of different employment types or frequencies are available for our leave and for our program. the one important reminder is that our program does require that you are employed at the time of application. So again, part-time, seasonal, temporary employees are also eligible for the benefit.
Great. That syncs with another question. So can an employee be eligible for parental leave if the birth of a child happened before they started their position with the current employer?
Yes, someone would be eligible for paid benefits due to that event. It's unlikely that that person would be eligible for job protection under FMLA or DCFMLA. There are some scenarios involving, if you worked for a place and then went to work for a different place and then came back, that your eligibility for FMLA might carry over. But if you start with a brand new employer and you had a baby in the past year, you would not be eligible for FMLA or DCFMLA. So that's one of the crucial distinctions, that our program may very well pay benefits if someone files for benefits and is out of work, but they would not be entitled to the important job protections, including the right to return to an equal or better job when they come back, or the maintenance of health coverage while they're out, and other important job protections under DCFMLA and FMLA. They would not be entitled to those, likely. And so that is a very crucial distinction that we want employers and employees to be aware of.
Great, thanks. Is there a difference in leave or benefit eligibility for the birth of multiples, like twins or triplets?
There's no difference. And the reason isn't because they're twins or because you didn't have two qualifying events. You did actually have two qualifying events. You had two babies or welcomed two new babies into your household, but the rule that controls here is that you can only receive up to 8 weeks of leave in a 52-week period, regardless of the number of qualifying events. So if you had one baby and you took 8 weeks of paid leave to bond with that baby, you would not receive another 8 weeks to bond with the other baby because of the overall cap of 8 weeks. So you could, if you wanted to, for symbolic purposes, divide it into 4 and 4, but there's no difference in the amount of benefits you would receive from our program.
Great, thanks. Let me see here. So this is a popular question, is the money that employees received taxed, and is it subject to Social Security withholding?
So the money that an individual receives from our program is not subject to Social Security withholding, and that is because the money that is paid from this program goes directly from our office or the DC Treasury directly to the individual without being passed through the employer. So employers do not track or manage, or even in some cases know what an employee is receiving from this program. So they have no responsibilities to report any tax liability from this program. On the first question about the actual tax liability that an individual faces, it is likely that the benefits are taxable at both the federal and the state level, but currently, both federal and local tax authorities have not provided clear guidance on the taxable status of these benefits. This is the case in multiple states with paid family leave programs, with the exception of California, which did receive specific guidance from the IRS on the taxable status of benefits. That said, it is very likely that these benefits in our state, in DC, are taxable for the purposes of income tax at the federal level and for state income tax purposes for the states that tax unemployment compensation. Not all states tax unemployment compensation. Virginia is an example. Maryland and DC do. So this is all to say that individuals should be sure to contact their taxing authorities, or if they feel it is appropriate, a tax attorney to learn about the tax implications that might result from receiving paid family leave benefits. But the point of comfort I can offer to employers is that employers have no liability or responsibility to track, manage, report, or in any way handle the benefits or tax liabilities that result from their employees receiving these benefits.
Very helpful, thank you. So going back to sort of the timeline, someone was asking, so what's the longest amount of time theoretically that an employee could expect to wait from the time they submit their application to when they receive their first payment? Would it be up to 24 days if we're thinking a 10-day processing period, and then up to another 2 weeks for a bi-monthly payment?
That would be a correct assessment. That is the maximum amount of time that could elapse between filing a benefit and receiving a payment. 2 weeks to process the claim, and then 2 weeks to issue the payment. That said, that's an unlikely scenario. The 2-week turnaround time is, again, the maximum. And after we approve a claim, the payment will go out, if all goes right, the next Tuesday, the second business day of the week. That's when our biweekly payments go out. So you would receive payment the following Tuesday. It's possible it could be longer if you choose to start benefits at a later date. And this would happen when, so let's say you file for benefits because you have to take care of your mother who is sick next month. And you know that she's going to be in a healthcare facility next month and this month, but you're going to take care of her next month. You could still file for benefits and just have them locked in for next month, but you would not receive the benefits for that until after you actually took care of your mother next month. And so that would delay the payment, not because there's any administrative delay, but just because you didn't actually take off from work yet, so you're not entitled to the benefits yet. So yes, 4 weeks would be the maximum if you wanted benefits immediately, but it's unlikely that it would actually be that long in most cases.
Great. Sort of a related point here. Can an employee choose to save their PFL for later and not take it, even if they are absent for a PFL qualifying leave reason?
Yes, someone could save their PFL leave, but someone cannot receive retroactive benefits for leave already taken. So it would have to be a specific scenario where you wanted to do this and where the worker was confident enough that their job was secure or protected under other leave laws, potentially. If you have a baby, or one of your workers, one of your employees has a baby, and they're out for a number of weeks, and their job is protected under other leave laws, that protected leave doesn't extend to paid family leave when they choose to take it in the future. So they've already elapsed some of their job protected leave under FMLA or DC FMLA. So you could save it. You don't have to take it right when your qualifying event occurs, but you should be cautious about making sure that your job protection is extended through the period that you want to take the paid family leave benefits.
Okay, great. So I have about 5 questions with this kind of flavor. So I'll bundle them together, and it's a 2-part question. But a lot of attendees want to confirm. So it could be possible that an employee receives both their company's PTO and PFL benefits for the same time. And then secondly, can an employer require an employee to apply for PFL before using their PTO benefits, for example, their sick leave or other leave benefits?
And the answer, or the answers there, would be yes and yes. So again, our program does not offset, except for two instances. We do not allow, under our law, for an individual to receive paid leave benefits when they are also receiving unemployment compensation or if they're receiving long-term disability payments. But if an employer has their own short-term disability plan or PTO plan, we won't offset for that. So theoretically, yes, an employee could receive both benefits if the employer's policy allows for it. And then kind of getting into that latter question, yes, the employer could make their benefits contingent upon the employee filing for paid leave first. So we offer 8 weeks up to $1,000 per week. And the employer could indicate, okay, you have a qualifying event that's eligible for paid family leave. You should file a claim with PFL. And then the employer could then dictate how their program wraps around. So maybe, again, we pay $1,000 a week or up to $1,000 a week. And there are some employees who would be receiving more than that per week. So the employer could then top them off to get to their average weekly wage, or the employer could have them utilize all of the available leave under PFL, and then whatever the remaining time required for their qualifying event, the employer could then accommodate in their pay time off plan.
Great, excellent. And I just got another sort of related question. So if an employee is on FMLA and using their PTO to get paid, can they also get paid PFL at the same time? So another question in the same theme, and the answer would be yes, if you allowed that kind of
yes, if the employer payment policy allowed for that payment to occur, yes, because the district is going to pay if there's a qualifying event that we approve, or there's a claim for a qualifying event that we approve. They're going to receive the payments from the district. Now, in terms of the employer's payments for their PTO, that's going to be under their established policy. But one important reminder is that with the Accrued Sick and Safe Leave Act, for example, 3 to 7 days that are guaranteed under law. So that's one of the interesting cases where we have two laws that there could be some overlap for, and both laws protect those benefits. So the PFL program is going to pay those benefits, and if the individual happened to have paid sick time that could be used for that time as well, that would be allowable. So there are some interesting interactions, but primarily the employer will control what happens with their PTO plans.
And the other part of that question about FMLA, I do want to make the distinction that from the previous question about can you save PFL, and this question asks about taking PTO, that is FMLA protected. So you could save, that's not a word we would use, but you could delay applying for PFL if you wanted. But the US Department of Labor's Office of Wage and Hour recently released guidance about FMLA, and their guidance was that you cannot delay FMLA leave. So if you have a qualifying event and you take leave because of that qualifying event, you're not allowed to, a worker, an employee, is not allowed to take that leave and have it not count for FMLA leave. So you couldn't just have a baby, say you're going to bond with the baby, but you don't want it to count for FMLA yet because you're sure you're not going to get fired, and then take FMLA leave that is job protected later. That would essentially increase your entitlement to job protected FMLA leave. So that's another caution for people who are thinking about taking PTO and having that wrap around in some way, and then delaying paid family leave. You are not allowed to just merge all these things and have them all be job protected. FMLA leave has its own distinct restrictions on what kind of leave is required to count for against your FMLA leave entitlement.
Okay, great. If an employee does file a claim, does that affect the organization's PFL tax rate?
So our program does not have experience rating. So with the unemployment insurance program, you have a variable rate dependent upon the number of claims that are filed. But for the paid leave program, there is a flat 0.62% rate for all employers, while the overall rate for the program might change for everyone, and that there's a requirement in the law that the Office of the Chief Financial Officer review the solvency of our fund every year, beginning with I believe 2021, and then to make recommendations to the council as to whether or not the tax rate or the benefit amount should be adjusted. But generally speaking, no. The amount of claims filed against, they're not filed against an employer, rather. The amount of claims filed by your employees does not impact your tax rate.
Awesome. This is an interesting question. So could an employer offer to float its employees while DOES is processing a PFL claim? So for example, during the 7-day waiting period or the claims processing period, could an employer pay the employees during that period and then sort of recover the PFL that they receive afterwards to offset the amount that they floated?
So sort of a two-part question. So the first part about paying employees during the waiting week, that is absolutely allowed and would be a sensible policy. And in some cases, it would almost be required for some qualifying events due to the interaction with the Accrued Sick and Safe Leave Act, which, as Michael covered, requires between 3 and 7 paid sick days a year. And so if someone is out of work for there's that 7-day waiting period and it qualifies as leave under the Accrued Sick and Safe Leave Act and PFL, then they could be eligible for full wage replacement under the Accrued Sick and Safe Leave Act. So that's one piece of it. But the part about being reimbursed from the program, that answer would be no. Well, at least from the perspective of the program. So our benefits by law are paid directly to the individual, to the worker. That's how we will address all of the payments are to the eligible individual. Whatever kinds of arrangements, private arrangements an employee might have with an employer as far as reimbursing benefits is completely between them. So if an employer knowingly wants to offer some kind of, it's essentially a loan during a 7-day waiting period, they could work that out. It could be a potentially complicated mechanism that they want to work out with future accrued days or however they want to work it out. But for the program, we just issue payments directly to individuals, and then the individual is free to spend the money how they see fit.
Great, thanks. I'm trying to make sure I'm parsing this one right, but someone has asked, how will employees know when employers know when staff are approved? I guess when.
Yeah.
I got you. I'm trying to work out the timeline. Yeah.
Interesting. So, we will always tell employers when a claim is filed, and we will always tell employers that a claim has been approved or denied. We will always tell them that. So employees can rest assured that their employers know about this. The only piece of that we might withhold if the employee asks us to is the benefit amount. And again, we encourage employees to have us disclose the benefit amount because of the rule that employers are allowed to withhold any benefits that they want if they don't know what they're coordinating with. But that's the only piece that we may not share with the employer, but all the other claim details about the period, especially the period of leave and the specific days that someone has told us they're going to be out and that we're paying them for, that is being communicated in all instances to the employer. So there's no doubt in the employee's mind that that happened. In terms of the question about when they will know, we will issue all of this correspondence at the same time electronically. So as soon as an employee knows about something, we've sent a similar piece of correspondence to the employer at the same time through email. So that everyone should be on the same page at the same time under this program.
Great, thank you. We had another question. Does this program affect the 1099 contractors, independent contractors who might work for an organization or an employer?
That's going to depend. So our program does allow for self-employed individuals to opt in. We do have very specific opt-in periods. We have open enrollment November and December each year. And then also in the case of new self-employed individuals, the first 60 days following the commencement of their business. Because generally speaking, 1099 employees, they're not going to have their income reported by the employer as wages. They report that independently if they are truly 1099 employees. But we always want to remind employers to make sure that they are following all the appropriate rules, regulations, and laws related to worker classification and wage reporting. But if you are an independent worker or self-employed individual, you will have the opportunity to enroll in the program and then contribute contributions yourself or pay taxes yourself based on the wages or the income, the self-employment income that you are reporting to our agency.
Great, awesome. And just picking up on Michael's point about making sure that we're classifying people correctly as independent contractors versus employers, we have a lot of resources on our website on that topic. So that's again at probono.center/NPSB. There's an employment law section. Okay, moving along. Have there been any changes to the PFL program based on the COVID-19 pandemic?
There haven't been any official changes in policy or administration due to the COVID-19 pandemic. Our definition of serious health condition remains the same. And there are instances where positive cases of COVID-19 would be eligible for paid leave benefits, and other instances where individuals who are positive with COVID are not eligible for paid family leave benefits. But that's not the result of a change in policy in any way with the program. That's just a novel disease that has become prevalent in the United States, and our program covering it in the way that it would cover any other disease. So no, there haven't been any specific changes, but we can talk more about the coverage of COVID if that's something that people are interested in.
Great, thanks. And we'll allow people to ask some follow-up questions in that area as well. But meanwhile, someone's asking, just to confirm, a person must be employed at the time in order to apply for PFL benefits. Is that correct?
Yes, that's correct.
Okay, great. And this echoes a question that was asked earlier, but probably makes sense to return to it and emphasize. So if an employee had a qualifying event like the birth of a child in April 2020, they could still apply in July 2020 for that qualifying event?
Yes, they could, but the important thing to remember is that we will only pay benefits for leave that actually occurs after July 1, 2020. So if there was a birth that occurred in April, any leave that was taken between April and July 1st would not be eligible for a payment. But if you were actually taking leave to bond with that child on or after July 1, then yes, that qualifying event would be eligible. And again, an additional reminder, we would look back at the wages that had been reported prior to that qualifying event. So in the case of a birth in April, we would be looking back at the completed calendar quarters before. So that would be starting with Q1 of 2020, which is January, February, March, and then any preceding quarters before that.
Great, thanks. Someone's asking, when you're averaging, this relates to that, when you're averaging wages to figure out the base period, do the quarters have to be continuous? For example, if someone worked for 2 quarters, was laid off for one during COVID, and then rehired for 2 quarters, how would that affect the benefit calculation?
So we use the highest 4 of the 5 completed calendar quarters before the event. So we would, if someone was laid off for a full quarter, that quarter would likely be dropped out of the calculation. So the wages in that quarter would be 0. So they would be dropped out, and then the other higher 4 quarters would be used to calculate the average. That said, there's no rule against a quarter with 0 wages being used. So if someone was laid off for 2 full quarters, one of those quarters would be included in the benefit calculation as a 0. So that would bring down the average wages over the 52-week period.
Great, got it. Another question, how does PFL interact with laws that provide leave as an accommodation, like for pregnant workers or for workers with disability not covered by DC or FMLA?
In the same way that the leave would interact with FMLA, DC FMLA, or the Accrued Sick and Safe Leave Act. And by that I mean that they are allowed to run concurrently, but they don't have to. So if someone is on leave due to some kind of accommodation, they would be allowed to take paid family leave and receive benefits during that period if they were eligible for both kinds of leave, but they wouldn't have to do so. No one has to apply for PFL leave. So all of the leave laws are still in existence, and individuals have to follow those rules just like they would with any other program. And we do like to remind people that this program doesn't provide leave. When the Office of Paid Family Leave approves a claim, we're not approving someone for leave or to go on leave from their employer. All we're doing is approving cash, money, to be transferred to that individual for a certain period that they're not working. Whether they've negotiated with their employer for that leave or not doesn't go into our determination about whether the person is eligible for benefits or not. We're just approving the payment of benefits, but all leave that is allowed by an employer has to go through the usual channels of either negotiation between an employer and an employee, or following existing leave laws, including laws protecting pregnant workers, or the more familiar FMLA, DC FMLA, and Accrued Sick and Safe Leave Act.
Awesome, thanks. Someone's asking, for DC and federal FMLA, what's the minimum number of employees required? If I'm not mistaken, federal FMLA is 50 employees and DC FMLA is 20 employees to trigger those.
Great.
Yeah, someone's asking.
Yeah, that's right.
Yeah, unless there's more you want to add.
No, perfect. Thanks.
Great. Someone's asking, does DOES have an average monthly claim projection for this program? How many claims are you projecting for the first month? And how many claims examiners has the office hired? This attendee is asking because they're noticing that in Washington, a mismatch between number of claims projected and number that they actually received have led to significant delays in claim processing. And they're hoping that this doesn't happen in DC. So I wanted to throw that out and get your thoughts.
Yeah,
we're hoping that as well.
Yeah, as a result of some of the recent hearings and developments at the executive level, there should be some additional information coming out regarding projections. Again, the Office of the Chief Financial Officer is required to certify our fund prior to the launch of the program. There will likely be some additional information made available regarding the OCFO's assessment of our fund. So we should have some additional information there. And then there should we also do a quarterly report that is submitted to council regarding the implementation of the program that often includes details about our staffing and program activities. So there should be some additional information made public very soon as well with regard to our most current implementation activities. But we are absolutely looking towards our fellow paid leave states for best practices and also to receive guidance on some of the challenges that they have faced. We have been in communication with Washington State, both leading up to and during the launch of their program. And we are absolutely keenly aware of the challenges that they are facing with their claim processing.
Okay, wonderful. And I know that those quarterly reports can be found on your DC Paid Family Leave website, which is again the URL on this final slide that is still up on the screen right now. That's it for questions so far, and we are kind of at the end of our hour anyways. So I'd like to thank you again, Michael and Elliot, for presenting today. I don't know if you have any closing words before we leave.
I just want to say
thank you for having us.
We are always glad to have the opportunity to speak to either the employer community or employees as well. Please stay tuned to our additional paid leave information. Please visit dcpaidfamilyleave.dc.gov. And if you have a question that didn't come up today, but that you might want to raise later, please feel free to reach out to us as well.
Yeah, thank you. And your contact information is here on the final slide. You can also go to that website one more time, probono.center/NPSB, for the contact information for us at the DC Bar Pro Bono Center's Nonprofit Small Business Legal Assistance Program. We're happy to answer questions as well. I think one takeaway from this, or something that might surprise people whenever I talk to them about the program, is that because there's that possibility of employees receiving overlapping benefits from your existing PTO plans and this new program, that employers do need to do some kind of affirmative work to analyze what their program currently is and what they want it to look like once the PFL program kicks in. So if you ever want to bounce ideas off about that process, you have a lot of resources and options for folks to contact. Okay, well, thanks again, everyone. Enjoy the rest of your afternoon. And again, thanks to our speakers. Bye, all.